In 1932, the US government launched a study on 399 black men in Alabama who had syphilis, and the men were never told they had the disease. They were never treated even after penicillin became available. They were simply observed for 40 years as the disease destroyed their bodies. And the study was called the Tuskegee Syphilis Study. It ran until 1972 when a whistleblower exposed it to the press, and the public outcry was immediate. Congress acted within 2 years, and out of that scandal came a law, the National Research Act of 1974, and that mandated the creation of something designed to make sure this could never happen again. And that something is Institutional Review Board, the IRB. And today I'm going to break down everything you need to know about it, what it is, who sits on it, what it does, how it reviews a clinical trial protocol, when it can suspend a study, and exactly how it connects to the IND, the Investigation New Drug Application. So the IND is an independent committee formally established to review, approve, and provide ongoing monitoring of biomedical and behavioral research that involve human subjects. Its core mission, in three words, is to protect people. So, before a single participant is enrolled in a study, before a single blood draw, before a single questionnaire is handed to a vulnerable patient, the IRB must review and approach the research. Let me break down the three pillars of what an IRB is. It's an ethical safeguard, legal mandate, and gatekeeper. So, ethical safeguard. The IRB operates on the foundation principle of Balmond Report. Landmark 1979 document that laid out that the ethical framework for human subjects research in the United States. Those three principles are respect for persons, meaning subjects are autonomous individuals who must give informed consent freely. Beneficence, meaning researchers must maximize benefit and minimize harm. And justice, meaning the benefit and burden of research must be distributed fairly across the society. So every IRB review in some form is an assessment of whether a proposed study uploads these principles. Next, the legal mandate. This is not optional. This is not a best practice for or a recommendations. IRB oversight is a federal legal requirement. So in United States, IRB are regulated under 45 CFR Part 46, the Common Rule, which cover federally funded research, and under 21 CFR Parts 50 and 56, which are FDA regulations covering clinical investigations of drug, biologic, and devices. Internationally, the ICH, Good Clinical Practice E6 guideline, which is a global standard for clinical trials, also mandate ethical committee oversight equivalent to IRB review. And there is no legal pathway to conduct human subject research that bypass this requirement. Next, the gatekeeper. So this is perhaps the most important practical point for anyone entering clinical trial. No human subject may be enrolled, no data may be collected, no intervention may be performed until the IRB has reviewed and issued a written approval for the study. Not even a screening visit, not even a phone call to recruit, if it involves a human subject and it's a part of the research. IRB approval must exist before it begins. The historical context matters here is the Tuskegee study I described at the start of this video ran for 40 years without independent oversight. And the IRB system exists specifically to ensure that it never happen again. It is not a bureaucratic formality, it is an ethical foundation on which all legitimate clinical research is built. So next is, now let us talk about a distinction that appear on almost every clinical research. IRB. What is the difference in IRB and IEC? So functionally there is no difference, but the detail matters. So IRB is Institutional Review Board, and it is a term used in United States specifically under FDA regulations and the US Department of Health and Human Services. If you are conducting a clinical trial regulated by FDA, the committee providing ethical oversight is called an IRB. Independence Ethics Committee is the term used internationally in Europe in the ICH-GCP guideline and in most countries outside the United States. So if the same trial is being run in Germany, Japan, or India, the body providing the exact same ethical oversight is called an ISA. Now let's go the key difference in terms of terminology and geographically. IRB is USA, IEC is everywhere else. So in terms of regulation, IRB are governed by 45 CFR Part 46 and 21 CFR Part 50 and 56. IEC is are governed by ICA GCP E6R2, the International Good Clinical Practice Guideline. For global multi-center trials, both sets of regulation often imply simultaneously, which means a sponsor may need both FDA compliant IRB approval in the USA and IEC approval in Europe. In terms of affiliation, an IRB is typically institutionally affiliated and it is tied to a hospital, university, or an independent review organization. An IEC can be fully independent, meaning it's not affiliated with any single institution, which is common in Europe and for international trials. In terms of scope, US IRB primarily govern federally funded or FDA regulated research. IEC under ICA GCP have a broader scope, applying to all clinical trials that fall under GCP standard globally. But again, there is a bottom line. The ethical mission is identical, and both the IRB and IEC exist to protect the right, safety, and dignity and well being of human research subjects. The name changes based on which regulatory framework govern the trial. The purpose never change. For multinational trial, which is most major phase 3 trials today, a study will obtain both IRB approval from every US site and IEC approval from every non-US site. And the sponsor coordinate this process, but each site is responsible for ensuring their own oversight committee has approved the protocol. Next, what is the composition of IRB? Now let us look who actually sits on IRB. Because the composition is not left to the institution discretion, it is precisely defined by federal regulation. Under 21 CFR section 56.107, an IRB must have at least 5 members, and those members must represent a diversity of backgrounds like scientific, non-scientific, professional, lay members. Let me go through all this one by one. So the scientist or physician, at least one member must have the scientific expertise, typically a physician, a pharmacologist, a biostatistician, or a researcher with direct experience in clinical trials. This person evaluates the scientific and medical validity of the protocol, assessing whether the endpoints are measurable, whether the sample size is justified, whether the safety monitoring is adequate. Now, next, non-scientist. At least one member must have a primary background outside science. This could be a lawyer, an ethicist, a chaplain, a nurse, or a someone from humanities background. This requirement ensures that the IRB does not become a rubber stamp for science, that there is always a voice asking, is this right? Rather than just, is this methodologically sound? Next, the community member, the unaffiliated member. At least one member must not be affiliated with the institution where the IRB is based. So there must be not an employee, faculty member, or immediate family member of anyone of the institution. This is the voice of public, someone who represents the interest of potential research participant without any institution loyalty or financial conflict. IRB chair. The chair is an experienced member who run the board meeting, ensure quorum is present, facilitate the deliberation, the sign, the official approval, correspondence letter. So the chair has significant authority in shaping the direction of reviews. Specialist members. For complex or specialized protocol, the IRB may invite or appoint specialists as needed. For example, a pediatric subspecialist for trials involving children, a pharmacist for complex drug interaction studies, or a statistician for studies with novel adaptive design. Next, the last sixth one, that is the conflict of interest rule. So this is mandatory and non-negotiable. Any IRB member who has a competing interest in a protocol being reviewed, financial or otherwise, must fully recuse themselves from the review and voting for that protocol. They may not even be present in the room during the deliberation. This is a hard rule. It exists to prevent the review process from being corrupted by relationships between board members and the sponsor. One more important note on composition is when the IRB review research involving vulnerable populations like prisoners, at least one member of the IRB must be a prisoner or the prisoner representative. This population specific representation requirement is built into the federal regulation to ensure that the IRB is not taking any decision about population they don't understand or represent. So that is also a composition part of IRB. Next is responsibilities and functions. So now what does the IRB actually do? Let's go through the 6 core responsibilities. Initial protocol review. So before any research begins, the IRB conduct a formal review of entire study protocol. This includes study design, the objective, the inclusion exclusion criteria, investigational product, risk assessment, and the data collection procedure, and the informed consent documents. The IRB can approve the protocol as submitted, require modifications before approval, or reject it entirely. Rejection is rare, so usually the IRB works with investigator to bring a protocol to approve standards, but it is absolutely within their authority. Next, informed consent oversight. So one of the most critical function of IRB is ensuring that the informed consent process meet all regulatory and ethical requirements. Under 21 CFR 50, informed consent must include 8 specific required elements. Now, means it includes a description of study, forcible risk and discomfort, potential benefit, confidentiality, information on compensation, treatment in case of injury, contact information, and a clear statement that participation is voluntary and refusal will not result in any kind of penalty. So the IRB review the consent form word by word at an appropriate reading level in the subject language free of misleading language. Third, risk benefit assessment. The IRB must make an explicit determination that the risks to subjects are minimized and those risks that are reasonable in relation to anticipated benefit. This is not just about patient safety, it is about the societal value of knowledge to be gained. High risk studies are not automatically rejected. Phase 1 oncology trial involving significant toxicity may be entirely justified if the potential benefit in patient with no other option is proportionate. So IRB make that judgment. Vulnerable population protection. Certain groups of research subjects require special protections under federal regulations like children, pregnant women, prisoners, economically or educationally disadvantaged individuals who may be susceptible to this. For these populations, the IRB applies additional scrutiny. For example, research involving children require that the risk be no greater than those ordinarily encountered in daily life or that the potential benefit be direct. Separate consent category, assent, and the parent permission apply. Now, next is adverse event review. If the IRB is not finished once a study starts, or investigators are required to report serious ADE, unanticipated problems involving risk to the subject, and protocol deviation to IRB in the timely manner. So, it will the keep on going process. And IRB review these reports to determine whether they change the risk benefits assessment or not. Continuing review. So we'll cover this in full of its own section, but briefly, IRB approval is not permanent. It expires. Studies must be re-reviewed on a regular schedule, and that review must be genuine, not a rubber stamp. Next, 3 review pathway. So when a new protocol is submitted to the IRB, it does not automatically go to a full board meeting. There are 3 distinct review pathways. The pathway 1 is exempt review. So this exempt review is this is for the research that poses minimal risk for and fall into one of specifically defined category under 45 CFR 46.104. Example include research using educational test or survey in normal educational setting. Research with existing data where subjects cannot be identified and certain observation studies of public behavior. The key point that researchers cannot self-certify, self-declare that their own study is exempt. The determination must be made by IRB. And if a study qualified for exempt status, it does not require full board review or annual continuing review. But it still must be processed by IRB. Next comes after that, pathway 2 is expedited review. So this pathway is for research that pose no more than minimal risk and fall into one of 9 specific categories defined by FDA regulations, such as collection of blood sample by standard venipuncture, collection of biological specimen, review of medical records or charts. In this review, the protocol is reviewed by IRB chair or may by one or more experienced reviewer designed by that chair. But and this is important that the study cannot begin until the expedited review is complete and a return approval is issued. Expedited means faster, not absent. Pathway 3 is full board review. So this is required for any research involving more than minimal risk. And this is where the vast majority of clinical trials fall, phase 1, 2, and 3 drug studies trials, with invasive procedures, research involving vulnerable populations where subjects are exposed to physical, psychological, or social risk beyond everyday experience. For full board review, a quorum of IRB member must be physically present, and federal regulation define quorum as a majority of voting members. So the protocol is reviewed in depth, board members deliberate openly, questions are raised, and the investigator may be invited to address the board. A full board meeting must result in one of three outcomes for each protocol: approve, approve with required modifications, or not approve. If approved with modification, the investigator must address every required change, and the IRB must confirm that those changes were made before issuing a final approval letter. Next comes, here is something that surprised many people, which is new to the clinical research. Getting your IRB approval is not the finish line, it's the starting line. So IRB approval has an expiration date. Under federal regulation, every active study subject IRB oversight must be reviewed and reapproved at intervals not exceeding 12 months. And the IRB can set shorter review intervals every 6 months, every 3 months if the risk level of study warrants. So now, step by step, if we'll go, the step one is investigators submit a progress report. Before the approval period expires, the principal investigators submit continuing review report to IRB. This report typically includes number of subjects enrolled to the date, the number who have completed the study, any protocol deviation that took place, any updated consent form. IRB need this information to reassess with real data, not predictions. Then the IRB review the submission. The review itself follows similar pathway, expedited or full board, depending on the study risk profile. The IRB evaluate the new safety data, assess whether the original risk benefit calculations still hold, and review whether the study is being conducted. Third, IRB takes action. Now, once it is, the IRB can reapprove the study for another approval period. It can require modification. It can increase the oversight frequency. New approval letter issued. If the study is reapproved, a new approval letter is issued with a new expiration date. The study may continue. Now, what happens if a study continue after its IRB approval has lapsed without renewal? So, lapse. This is a serious regulatory violation. Conducting research after IRB approval has expired without a renewal in place constitute a protocol deviation that must be reported to IRB and potentially to FD. Enrollment must stop. Any data collected during the lapse period may be compromised, and the investigator may face sanctions. So, this is not a theoretical risk. It happens in real trial, particularly when investigators fail to track their approval expiration date carefully. Then, when IRB can suspend and terminate. Now we get to the IRB most significant and powerful authority, the ability to stop a clinical trial. How it happens? Under 21 CFR 56.113, the IRB has the explicit authority to suspend or terminate approval of research that is not being conducted in accordance with IRB requirement. This is not rare, a nuclear option. So IRB exercise this authority when the situation demand it. Now let's look at the specific grounds on which a suspension or termination can be happen. Unexpected serious harm. So the most urgent ground, if serious adverse event emerge during the trial that were not anticipated in the protocol, events that are both serious and reasonably possibly related to investigation intervention. The IRB must act immediately. Next, protocol non compliance. So, if the investigator is not conducting the study in accordance with the approved protocol, wrong dose is given, wrong visits missed, wrong eligibility criteria applied, consent process not followed, and this protects subject from risk that arise from deviation from a carefully reviewed protocol if the IRB will suspend the study. So next is risk outweigh benefit. So what happens? Data Safety Monitoring Board reports interim analysis, and this board reports or a new information from other studies may reveal that the risk profile of the intervention is worse than expected. So if the risk benefit ratio is tilted such that continuing the study can no longer be ethically justified and the IRB must act. False and fraudulent data. So the scientific misconduct, fabricating data, falsifying records, misrepresenting finding in report to IRB. Then consent violation. If the subjects were enrolled without valid information consent, whether because the consent form was unapproved, because the consent process was coercive, or because the subjects were not given adequate time or information, IRB can suspend. Last, regulatory non-compliance. So failure to support SAE to the IRB in the required time frame, failure to submit protocol amendments before implementing changes, failure to respond to IRB risk. Now, what happens after a suspension? So, the IRB must prepare a written report of its finding, and this report must be provided to investigator, the institution, and critically to any applicable federal regulatory agencies like FDA. So, the investigator cannot resume the trial until the IRB officially lifts the suspension. Now, what is the relationship between this IRB and IND? The IND finally means the investigation new drug applications, because understanding these two processes interact is critical for anyone working in the drug development. IND is the investigation new drug application, is a regulatory filing submitted to the FDA before any clinical study involving an investigation new drug. IND contain preclinical data like animal studies, pharmacology, toxicology that establish enough safety data to justify first in human testing. Once the IND is filed, the FDA has 30 days to review it, and the FDA does not place the IND on clinical hold. How does the IND relate? The IND and IRB approval process are parallel, both. They happen simultaneously. Neither process waits for other to complete before beginning. The sponsor files the IND with the FDA at the same time they submit protocol to IRB for review. Both process must be complete before the first subject can be dosed. So, if the FDA approved the IND but the IRB has not yet issued approval, the study cannot start. If the IRB approved the protocol but the IND is still under FDA review, the study cannot start. So, both gates must be open. Now, how do they interact when the study is running? When protocol amendments are made, changes to the dose, study schedule, the eligibility criteria, the consent form, and the sponsor must submit the amendment both to FDA as an IND amendment and to the IRB for approval. Neither party can be bypassed. When serious adverse event occur, the sponsor must file an expedited IND safety report to FDA and must also report the event to IRB. Two separate regulatory obligations, same triggering event. When the study needs to stop, either body can act independently. The FDA can place the IND on clinical hold, which halt all investigators under that IND globally, and the IRB can suspend its approval for a specific site, which halt enrollment at that site regardlessly of what the FDA has done. Now, this is the most important practical implication for anyone in sponsor or site operation. The FDA and IRB each have independent authority to stop the trial. The FDA does it by clinical hold in IND. The IRB does it by suspension. And these actions are independent. One does not require the other. Conversely, to run the trial, both need to be in state of approval simultaneously. IND active and IRB approved. Now let's close with this video with the IRB details. What we have done, I have explained it today is IRB is a federally mandated independent committee. IRB and IEC are functionally identical. IRB must have at least 5 members and including scientists, non-scientists, and an unaffiliated community member. There are three review pathways: exempt, expedited, and full board. IRB approval is not permanent. The IND and IRB approval are parallel independent requirements. Both must be in place before the first subject is dosed. So if this video helped you, whether you are studying for an exam or just trying to understand the system that protect people in clinical trials, please hit the like button, and it takes 1 second and genuinely help this content reach the people who need it. If you haven't subscribed yet, please do. We cover clinical research, regulatory science, pharmacotherapeutics, pharmacy related subjects. Drop your questions in the comment, and if you want me to explain any other topic, please tell me in the comment. Thank you for watching, and I will see you in the next one.